morning.
Good morning.
It's my honor and pleasure to join this group, this conversation this morning, to commemorate Constitution Day, a moment to reflect on the enduring framework that protects our democracy and guides our civic life. And I'm very energized by learning about different student groups who are engaged in civic conversation, civic engagement. It's very promising for me. I especially want to thank our faculty and staff for organizing today's event and selecting a timely and thought-provoking theme, Guardrails on Democracy, the Role of Separation of Powers. I think this has become more prominent in recent years, especially for students. I would like to invite you to think about what is separation of power and where we are right now on separation of power. This principle remains a vital safeguard that ensures balance, accountability, and preservation of our liberty. This is the golden principle out from the Constitution. We are happy to welcome University of Chicago Law Professor Stephen Chauvin, a distinguished scholar whose insight will deepen our understanding of this year's theme and why it matters to each of us. At College of DuPage, we believe education is essential to a thriving democracy, and the role of students sitting here and outside this hall is critical. Through civic engagement and critical inquiry, our students become informed citizens and thoughtful leaders. The intent is to prepare students so they are aware of what's going on in their environment, participate in our democratic process. And this seminar is part of that intent. I hope you come away from today's presentation and lecture from a leading scholar. Uphold the values of justice, integrity, and service that strengthen our communities and our nation. Thank you very much.
Thank you so much, Dr. Siddiqui, and thank you for giving voice to the importance of this topic right now. We appreciate you. So my name is Annie Knight. I'm the chair of the Legal Studies program here at College of DuPage. Before we get started and I introduce our fabulous speaker today, I just want to go through a few housekeeping items. So first, just so everybody knows, this presentation will be recorded and available on the College of DuPage Constitution Day website. So if you're interested in other Constitution Day resources or you want to view the recording, or tell your friends to view the recording, or you can go to the college website and search Constitution Day there. Also, time permitting, we will be doing question and answer at the end of the presentation. We will also have, however, a microphone available within the room for you to ask questions after the event, again, time permitting, so you can ask questions both of those ways. Either scan the QR code and enter your questions, and then once we've gone through all the submitted questions, we will go to the room for additional questions. Our community guidelines, remember that you communicate with courtesy and respect, challenge yourself to listen to others, be tolerant towards others' viewpoints, respectfully disagree with opinions you do not align with, and then more of a housekeeping matter, we do recognize that some of you may have to leave for class around 11:50 or 12:15. If that's the case, we completely understand, and don't take that personal. Professor Schwinn, but please do so quietly so as not to disturb the rest of the presentation. So now, at this time, I'd like to introduce you to our keynote speaker today, Professor Stephen Schwinn. Stephen Schwinn teaches constitutional law, comparative constitutional law, human rights, and a specially designated legal writing class on civil rights. Stephen is founding editor-in-chief of the American Constitution Society's Supreme Court Review and founding co-editor of the Constitutional Law Prof blog, which I used to look at all the time in law school, so I love that. He's a longtime member of the American Constitution Society Chicago Lawyers Chapter Board of Advisors. Steve regularly works with high school teachers and students on civic education, and he regularly speaks on issues related to constitutional law and public policy. Steve's writings have appeared in a variety of law reviews and other specialized periodicals, popular press publications, and online publications. He regularly writes for the American Bar Association Preview on United States Supreme Court cases and is a frequent commenter on issues related to constitutional law and human rights. Professor Schwinn teaches constitutional law, First Amendment, comparative constitutional law, human rights, and lawyering skills civil rights at UIC Law. He previously served as co-director of the International Human Rights Clinic, director of the clinical program, and the Edward T. and Noble W. Lee Chair in Constitutional Law for the 2015-2016 school year and the spring semester of 2023. Professor Schwinn earned his BA from Michigan State University and his JD from American University Washington College of Law. He previously taught at the University of Maryland School of Law and George Washington University School of Law. He practiced full-time in the Office of the General Counsel at the Peace Corps. So at this time, I'd like to welcome Professor Stephen Schwinn to present today's keynote presentation on the Guardrails of Democracy, the role of separation of powers today. So please welcome Professor Schwinn.
Hey, good morning, everybody, and happy Constitution Day. Wait, happy Constitution Day. All right, all right. Annie, I want to thank you for that very kind introduction. Mr. President, thank you for hosting us today. And the committee, what a wonderful honor to be here with you all today. I really appreciate this opportunity. Your programming here is amazing, and your facilities here are amazing. I was telling the group before the session today, yes, indeed. I was telling the group, and maybe turn off the camera for this, I was telling the group before the session, I got to write back to my dean and say, we got to up our game at the law school because you got it going on here at COD. This is really exciting stuff. Wonderful civic engagement. I'm really happy to hear about the programs that you're offering and that you're growing here at COD around civic engagement. Such a critical time for us to be having conversations like this. And I want to acknowledge kind of right out of the gate, the topic, Guardrails of Democracy, the role of separation of powers today. I'm going to take credit for that. And it's a sleeper, and I get it. But what I'm going to try to do is make this interesting and impactful for you with what's going on in politics today. I think there are trends that we need to be keeping our eye on. There are trends related to our democracy, related to separation of powers, related to democratic backsliding, and related to a move toward authoritarianism that I think we all ought to be worried about no matter what our politics are. And so you might agree with me at the end of the class today, or maybe you don't, and that's okay. Agreement and disagreement is what democracy is all about. But what I hope to leave you with is a sense, at least one sense, of what's going on in our democracy today. As a student asked me last spring, after the new administration took office, in my con law class, he just kind of raised his hand and he said, Professor, I don't know how to ask this, but what the hell is going on? And I said, I don't know. I don't know. We got to figure this out. I've been teaching constitutional law for a long time, longer than I'll say. And this is a very unusual moment in our constitutional system. It's a singular moment in our constitutional history like no other. We've had other constitutional moments, sure we have. And maybe even bigger constitutional moments than this, sure we have. But this is a moment, and we need to keep our eye on it. We need to understand what's going on. And so I hope the talk today will help us move in that direction. Now, having said that, I want to say, I've got a little PowerPoint here. I'm going to go through. I've got my slides, whatever. I hope that you'll feel free as we go through this to interrupt me with questions and comments. As I tell my students, you will kindly keep your complaints to yourself, but questions and comments are joyfully welcomed throughout, and then we'll leave time for Q&A at the end as well, if I can manage to keep my eye on the time with the help of my good friends. Are we good? Yeah? All right, so let's go ahead and get started. Guardrails of Democracy, the role of separation of powers today. Okay, by the way, my email is up there. Feel free to drop me any emails afterwards or during. I'd love to hear from y'all. So what are we going to talk about? What I'd like to talk about is first separation of powers basics, and you're going to help me out with this. I understand there's a political science class in the house, yeah? So you're going to know some of this, and I'm going to ask your help, just fair warning. The evolving separation of powers, kind of what's going on with our separation of powers today and why. I'm going to share my ideas with this as a longtime observer of separation of powers, and I'll be interested in your feedback. The unitary executive theory. Anybody hear about this thing, unitary executive theory? Yeah, maybe some. Okay, we're going to try to define it with a little more specificity than the way we use it in our public discourse. We're going to see what it means legally and see how it's expanding legally. Really interesting issue that we need to keep our eye on. And then 3 examples that I have ripped from the headlines, things that are going on today that we can talk about and try to understand these things in the broader political context and historical context. And then again, of course, I welcome your comments or questions anytime. I want to say something right out of the gate. You know, I do a lot of work with civics groups in the Chicago area, Illinois, and around the country. And over the last 9 months or so, when I've been scheduling my talks, the deal has been we can sort of tentatively identify a topic that we might want to talk about on such and such date. But with the fire hose of stuff coming out of Washington, we know it's going to change, right? And so what's relevant today may relate to separation of powers. What's on your mind might have something to do with separation of powers, or maybe it doesn't. I'm happy to talk about anything. So if you want to talk about immigration enforcement, anti-DEI efforts, what's going on in higher education, whatever. I'm more than happy to engage with you about that, so please feel free. All right. So separation of powers basics. I heard a rumor that we have 3 branches of government, and I also heard a rumor that we have political science students in this house. So what are the 3 branches of government? Somebody help me. Executive, I love it. Okay, another. Judiciary, yes, and? Legislative branch, good, okay, good. So I've got Congress, the Article I branch. I've got the White House, the presidency, the Article II branch, although as we'll see in a second, it's much more than just the office of the presidency in the White House. And the Supreme Court. I love that picture of the Supreme Court. I was so glad to find that. Most of the court pictures are so ominous, but this one is really kind of joyful and happy. Now, we've got 3 branches of government, and we do have a separation of powers, right? And so let me just ask you, the political science students, what does Congress do? What does the legislature do? They make the law. Good. Okay, good. What does our Article II branch do? The executive branch. What does it do? Enforces law. Good. I'm glad to hear it. And the judiciary, what do the courts do? Article 3? They interpret the law. Okay, good. Now here, I just want to pause for a second because we talk a lot about separation of powers, but separation of powers is not the only thing that we have in our system, right? We do have, I think of it as kind of a stovepiped separation of powers. The legislature makes law, the executive enforces it, the judiciary decides cases and controversies under it. That's kind of an easy 3-part sequence, and we can keep a separation of powers. But really, what our system is about is not separation of powers, it's about checks and balances, right? Who can help me out? What are some of the checks and balances that are hardwired into our constitutional system? Anybody? What's one? Impeachment. Good. Okay, good. Impeachment. And so Congress can impeach, right? And that operates as a check on the president and officers in the executive branch, the Article II branch. It also can operate as a check on the courts, right? We can impeach judges. Good. Okay, what's another check? Yeah. 2/3 majority. Say a little bit more about that. What do you mean? Okay, good. So we've got a couple of things going on there. To pass law, right, it's got to go through both houses of Congress, bicameralism in the Constitution, and it has to be signed by the president or a veto override by 2/3 in both houses. And that's a kind of check on Congress's lawmaking power by the executive. Isn't that interesting? And then we divide the legislative power, right, so that no single house has too much power. Okay, good, with different lines of democratic accountability, interestingly, so that nobody has too much political power. Good, what's another check or balance, just to kind of get us going here? Veto, good. Veto meaning presidential veto of congressional legislation. Good, excellent, good. And so what we say is the president has agency in lawmaking, right? Congress has agency in executive authority. The courts obviously have agency because of judicial review in what's going on in both Congress and the executive branch, and we have these checks and balances. Now, the way the framers talked about our separation of powers and checks and balances is that these branches would push and pull against each other. They recognize that we're all human, that people in power are going to seek more power, but if we design our checks and balances so that the coordinate branches can push back, we'll keep every single branch in check, right? And so if the judiciary starts to get too big for its pants, right, we can expect the presidency and Congress to push back. If Congress starts to think it's all that, then we can see the judiciary and the executive start to push back. And in today's politics, if the, dare I say, the presidency starts to get too big, we would expect the coordinate branches to push back, wouldn't we? Well, part of what we're seeing in today's politics is they're not, right? The members of Congress are putting their party above their institution and not pushing back. The members of the Supreme Court, some would argue, many have argued, that they're putting their party before their institution and not sufficiently pushing back. And we're seeing an outsized presidency. And I just want to pause here for a second. You know, we all have different politics. I understand that. It's very difficult to talk about these things today without being political. In fact, it's impossible. I tell my students, you can't do it, and you shouldn't do it. Politics and constitutional law, they overlap. They're inextricably intertwined. You can't separate them. We got to talk about politics, but here's the thing. When we talk about separation of powers and checks and balances, the commitments that we make to those things have to operate both ways. We may like an outsized presidency when Trump is in office, but we need to understand that that same outsized presidency then will be exercised by a Democrat when a Democrat inevitably returns to the White House. And that will happen, right? Our constitutional commitments around separation of powers and checks and balances, they need to work both ways. And so maybe you like today's politics, that's great, good for you. But then imagine a president in the White House that you don't like with the same power. Are you still happy about it? Or maybe you dislike today's politics, you think the presidency is too powerful. Well, what do you think about a weakened presidency when your favored president is in office, right? Think about it both ways. All right, enough preaching about that. I want to talk a little bit more about separation of powers and drill just a little bit deeper, because this is a picture, but it's not the full picture. Let's try to get the full picture. So a fuller picture of separation of powers starts with Congress. Congress has the power under Article 1, Section 8 to create administrative agencies. Administrative agencies, name an administrative agency, anybody? The CDC, okay, good, another one. EPA, good, one more, just to keep us going. The FDA, okay, awesome, good, all right. So we've got a bunch of administrative agencies that Congress has created, it's vested with authority, and it has funded. Congress has the power to do that under Article 1 of the Constitution. But here's the thing, those agencies, they actually sit in the Article 2 branch. And so the president supervises them, right? Do you see the lines of accountability here? Congress creates, vests with authority, and funds the administrative agencies, but then they're overseen and supervised by the president. You can imagine that that can get a little hairy, right? And it does. Well, it gets even hairier because watch this. The Supreme Court, it gets to police those relationships and tell us when those are constitutional and when they're not constitutional. When has Congress overstepped by designing agencies that impermissibly encroach on the president's Article 2 powers? Or when has the president directed the agencies in a way that violates law that Congress passed, right? Those are important questions, and the courts can help us police that. Now, what's going on with separation of powers today? We need to understand the role of the agencies. That's critical to what's going on in separation of powers today, because what we're seeing is an attack on agencies, right? Now, again, I try to say that apolitically. Maybe you like that. Okay, that's great. Maybe you don't like it. Okay, that's great. Just make sure that your commitment is going to work both ways, right? If you like it, are you going to like it when the politics are different? If you don't like it, same question, right? Okay. All right, so evolving separation of powers. What do I think is going on in today's politics? Let me describe this. So I think what we're seeing is an outsized White House, a minimized power of the agencies, right? You can see that, how I have a big White House, small agencies. That's clever, isn't it? If it's not obvious yet, I suck at PowerPoint. And so what I really wanted to do is have a moving graphic where the White House is expanding, right, in real time that we could see. I have no idea how to do that. I'm lucky to get the pictures on the thing. So anyway, the White House is big. Congress is small. Congress has stepped back, and not just because Congress creates these agencies, vests them with authority, and funds them, but also on its own volition. Congress has just kind of stepped back and said, we're going to let the White House do what it wants to do, right? There's no oversight on the part of Congress these days. Again, because I think members of Congress are putting their party ahead of their institution and not pushing back against what's going on in the White House, the way that our framers understood and intended. Now, here's the thing that we don't often talk about. The White House is expanding, agencies are contracting, Congress is contracting, the Supreme Court is expanding. Why? Because the Supreme Court is enabling all this, and we'll talk about how and why in a second. The Supreme Court itself is becoming an immensely powerful institution in our democracy because it's enabling these trends. It's validating these trends. It's saying they're constitutional and that this can happen. That's something that we don't often talk about, but we need to be talking about. Now, what's weird about this is that it's the Supreme Court itself that is becoming more powerful. The lower federal courts are actually becoming less powerful. The Supreme Court itself and the office of the presidency are gaining in strength. Congress, the agencies, and the lower federal courts, they're contracting. And this is a worry in a separation of power system where all these branches need to be pushing and pulling against each other. That's how it's designed, and it's not working. Okay, so what's going on here? Well, let's start with the Supreme Court. The Supreme Court, over the last couple of decades, and maybe a little bit more than that, but in the last couple of decades, this trend has kind of accelerated. The Supreme Court has been moving in the direction of an expanded power of the presidency. Okay, let's represent that by this arrow. The Supreme Court has been moving in that direction in its jurisprudence, and that meets Project 2025, right? You know Project 2025? Everybody? Yeah, you've heard about this? Okay. So Project 2025 has a lot of different things going on in it, but one of the things going on in it is a kind of hyper-powered presidency. That's one thing that's going on. So what we have is a kind of jurisprudential trend meeting a political reality in 2025, and then the election of President Trump, who is willing to put these ideas into action, right, aggressively. And so we see this trend accelerate, right, represented by the arrow going up even more. We see this trend accelerate, and then the Supreme Court gets involved in a way I'll discuss in a second, accelerates it even more to create an enhanced power of the presidency. This trend line, expanding power of the presidency. Jurisprudence meets politics and explodes the office of the presidency, I think is what's going on in today's politics. Now, one piece of this that may be familiar to, maybe not, so I want to pause for a second and see. The shadow docket at the Supreme Court is where the Supreme Court has been involved in this most recently. The action at the Supreme Court today is on a so-called emergency docket or shadow docket. And on its shadow docket, it's ruling in ways that have empowered a presidency like we have never seen before in our country's history. It's actually quite breathtaking what's going on. When I say shadow docket or emergency docket, is that something that resonates with you? Have you heard about this? Let me pause a beat and talk about it. I'm just going to do a quick time check and make sure we're doing okay. Oh, yeah. Okay, so the Supreme Court has two dockets. One docket, its ordinary docket, is the one that we're familiar with. It's an appellate docket where it hears appeals from lower federal courts. It turns out the Supreme Court gets to decide which appeals it wants to hear and which ones it doesn't. That'd be kind of a nice job, right? Decide, I want to do this part of my job, but not that part of my job, which is why it's so nice to be on the Supreme Court. You get to decide what you want to do. So they decide which cases they want to take up. They hear about 70 every term. The term starts first Monday in October and runs through about May or June of the following year. And those are big cases, right? We've heard big cases in recent terms, Dobbs overturning Roe versus Wade, for example, some significant Second Amendment cases, really significant equal protection cases, other stuff, free speech, other stuff going on at the Supreme Court. That's its ordinary docket. What we haven't really talked a lot about until maybe the last 10 years is the Supreme Court's emergency docket. That's the second docket that the Supreme Court has. We call it the shadow docket because we don't often talk about it. It kind of lingers in the shadows. This is a docket that historically has been used for death row inmates kind of as a last-ditch effort to avoid their death sentence, file a petition on the emergency docket to the Supreme Court, arguing that some element of their conviction or appeal violated the Constitution, and therefore their punishment, their death sentence, should be stayed, should be put off until we can work things out, right? That kind of makes sense, doesn't it? You sort of want that sort of last-ditch appeal in a situation like that where we often make mistakes in the imposition of the death penalty, and you want to check on that. Well, the way it's been used most recently is a little bit different. The way it's been used most recently is when a losing party in the lower courts wants the lower court judgment halted while the underlying litigation goes forward. That losing party can go to the Supreme Court and ask for emergency relief to halt the order of the lower federal court while the litigation goes forward. Now, it's not a ruling on the merits, or at least in theory, it's not a ruling on the merits. What it is kind of what the court, I think, would say is maintaining the status quo pending the outcome of the lower court underlying challenge on the merits. Let me give you an example from the Trump administration. We've seen this time and time again in the Trump administration. There have been over 20 rulings on the shadow docket, and they cut wildly in favor of the administration. If the administration decides that it wants to cut all foreign aid, for example, and dismantle USAID, you know what USAID is, U.S. Agency for International Development, does really important work around the world. The Trump administration decides it wants to shut it down and stop funding and fire all its employees, right? And so a lawsuit ensues, the employees sue, they say you can't do that. And maybe the lower courts say, yeah, that's right, you can't do that. The president doesn't have that power. Remember, Congress created USAID, vested it with authority and funded it. Where does the president have authority to shut it down, right? Even if that's their policy preference, where's their constitutional authority to do it? The courts might say, okay, yeah, that's right. You can't do it, and puts in an injunction against the president taking that action. Then the president can go to the Supreme Court on the shadow docket and say, well, hey, that injunction interferes with my ability as president to direct the goings-on of a federal agency, USAID, right? I ought to have that power. I'm the head of Article 2, after all, right? Whereas Trump would say, I have the Article 2, I can do what I want. He can shut it down, right? And the Supreme Court says, temporarily, pending the outcome of the lower court litigation, yeah, shut it down. You can shut it down. We're going to stay that injunction, and you can go ahead and take the action. Now, the problem with that, the case goes on, right? And so maybe the courts eventually will rule in favor of not shutting down USAID or the Department of Education, or firing the head of the FTC, or firing Lisa Wood at the Federal Reserve, or sort of pick your headline from the Trump administration. Maybe the courts eventually will rule in favor of the plaintiffs in those cases. But in the meantime, the agency's gone away, the people are fired, they've moved on and done different things, right? the damage is done. And so these shadow docket rulings have really accelerated this trend. And I think what the Supreme Court might say is, well, look, these aren't rulings on the merits, and we're not trying to accelerate any trend. We're just trying to maintain the status quo and make sure that we, the judiciary, don't overstep our bounds in our separation of powers system. But in doing that, the political reality of the situation is that they're empowering the presidency. Do you see that? Does that make sense? All right, I'm going to pause just for a second. Do y'all have any questions on anything I've gone over so far? We doing okay? Yeah. Yeah, good question. So the question is, who has authority to bring a shadow docket case? Am I getting that right? So the loser, the person on a losing end of a preliminary injunction in the lower courts would have the power then to bring that. You and I couldn't unless we were parties to the litigation. It's got to be the losing side of the litigation. And in the Trump administration and in the Biden administration before it, what we've seen is that when the president loses, they're the ones who petition to the Supreme Court on the shadow docket to maintain what the court would call the status quo, that is the decision of the president before the courts got involved. Yeah, good question. Thank you. Others? Yeah.
Who started that trend? You mentioned before it was mostly about death penalty appeals. When did that transition to this becoming normal?
I would say, it's hard to say exactly when we normalized it, but it has accelerated under the Obama, Trump, Biden, and now super accelerated under the second Trump administration. And so this is a feature of our politics and constitutional system that I would say has really come to the fore in the last 10, 20 years. And we've seen it exercised in this way. We've not seen anything like the flurry of shadow docket rulings that we're seeing in the second Trump administration. And I think maybe for reasons, and again, I'm trying to be apolitical about this, but what Trump is doing is extraordinary, right? And those who like Trump would say, yeah, that's extraordinary, you're right. And those who dislike Trump, I hope would say, yeah, that's extraordinary, you're right. So I hope that's an apolitical statement. We're seeing very aggressive action on the part of the president, which then inspires the Supreme Court to get involved through the shadow docket and accelerate this trend, empowering the presidency. Yeah.
How about the clawbacks that are starting? When did that start? I mean, I don't remember that being a main thing before, where they've tried to take back funds that have already been appropriated.
Financial clawbacks. Yeah, this is really something, isn't it? I want to do a time check and see how deep I can get into that really important question that I want to address. So can we go off script for a second and talk about that? Is that okay, everybody? Okay. So where to start? Let's start at the beginning. Congress has the power of the purse, right? You've all heard that. Maybe you learned it as early as 6th grade civics. Congress has the power of the purse, not the presidency. What that means is that Congress has the authority to appropriate funds to fund these administrative agencies and to fund the operations of the federal government. That's Congress's authority. Now, what we don't often talk about is while Congress has the power of the purse, that also means that it has the power to telegraph priorities to the executive, right? If Congress is spending a bunch of money on civil rights enforcement and not so much money on environmental protection, that tells the executive that congressional priorities are with civil rights enforcement and not environmental protection, right? And the presidency doesn't have any power to use any additional funds to ramp up environmental protection if they don't like those priorities. That's the point. Congress gets to say, okay? Now, related to that, in the Nixon administration, way back when, the Nixon administration, President Nixon had this habit of not spending money that Congress had appropriated for projects that he didn't like politically. We have a word for that. It's called impoundment. The president impounds money that Congress validly authorized, validly appropriated to the executive branch. And then the president making a unilateral decision, hey, I don't like those priorities that Congress set out. I'm just not going to spend that money, right? That's called impoundment. So for a Nixon, for example, he might say, given our earlier hypothetical, I get that Congress is prioritizing civil rights enforcement and they've put a bunch of money behind the Department of Justice Civil Rights Division. I'm just not going to spend it. I'm going to shut that division down for policy reasons. That's impoundment. It's widely understood as unconstitutional. It's widely understood as the president impermissibly encroaching on the role of Congress to appropriate funds, Congress's role as appropriator. And again, maybe you like impoundment, maybe you don't, but think about it both ways, right? Think about the president you like and the president you don't like, and make sure that your commitment works both ways. So this idea of impoundment is widely considered unconstitutional. Congress came back after the Nixon administration and said, we're going to do something about this. We're going to enact what's called the Impoundment Control Act. Somebody super creative at Congress came up with that, right? The Impoundment Control Act. They ought to get a bonus for creativity. Wow. So the Impoundment Control Act, what it does is restrict the president's ability to impound funds, but also by statute gives the mechanism to the president to claw back money that has been previously appropriated. But here's the hitch. If the president moves to claw back money that's been previously appropriated, they have to get permission from Congress. Remember, we talked at the beginning about bicameralism and presentment? Well, appropriations laws are laws just like any other law. It requires bicameralism and presentment. If Congress is going to override an appropriations law through a clawback mechanism in the Impound Control Act, both houses of Congress have to approve the clawback, right? And so the president would submit their proposal to Congress to claw back appropriated funds, and then Congress would vote for it or vote against it. If they voted against it, then we're still in the position that the president has to spend those funds. If they vote for it, the funds are clawed back. Now, we've seen a couple iterations of this. We've seen the clawback work where the President Trump, has submitted funds for clawback. Think about public broadcasting, right? That I think was maybe the most high-profile example of this in recent months, where he submitted a proposal to claw back appropriated funds for public broadcasting. Congress passed it. They said, that's okay, we're going to claw it back, and the money then was clawed back. That's kind of one version, the cleanest version. That's the way it should work. Agree or disagree with the outcome, the separation of powers kind of worked, right? In a different example, Trump has been unilaterally, I'll use air quotes, clawing back, because really what he's been doing is impounding funds for different areas of the government. Maybe you've read and maybe you've been impacted here at COD by clawbacks of previously appropriated funds for federal grants for different research projects, right? We've heard about this in schools around the country, maybe most notably Harvard, but other schools as well. We're all touched by that. And the president is unilaterally holding back those funds for a variety of different policy reasons. That's an impoundment that's widely understood to be unconstitutional. Now, is anybody doing anything about it? Yeah, they're suing in the courts, but then you've got the shadow docket issue and all the problems that we've talked about. So the courts, as it turns out, we're discovering, are not institutionally well designed to push back in the way that the framers thought against a president who is bent on doing things that the courts otherwise could check. There's yet a third version of what's going on with impoundment, and there's a case right now. It's kind of an interesting situation. So under the Impound Control Act, Congress has 45 days to act on the president's request for a clawback, right? I'm going to get into the weeds here for a second, pardon me. So 45 days, right? Well, the federal fiscal year ends at the end of September. And so if the president submits a clawback request within 45 days of the end of the fiscal year, by the president's reckoning, if Congress doesn't act, those funds automatically expire. This is called a pocket rescission. Maybe you've read about this in the news. That's what's going on right now. So the Trump administration has counted days back, 45 days from the end of the federal fiscal year, and said, we're going to submit our clawback request within those 45 days. knowing full well that Congress doesn't have the institutional capability of acting on the clawback, but at the end of the fiscal year, the funds automatically expire because all funds automatically expire at the end of the fiscal year unless Congress provided for an extension or a multi-year appropriation, which in these cases they didn't. So by Trump's theory, that works, right? And we can impound money through this pocket impoundment and effectively claw back the money, sidestepping the Impound Control Act. Now, the General Accountability Office, the GAO, which polices this kind of thing, it's an agency of the federal government, we'll talk about independent agencies in a second, but a politically independent agency of the federal government has concluded at least twice that this kind of pocket clawback, pocket impoundment is unconstitutional. It violates the separation of powers. What they say is Congress has the power of the purse, not the president, and this kind of under the radar sort of backdoor way of impounding money is an impermissible encroachment by the president on Congress's prerogative to fund the government. What will the court say, or will the court say? There are a variety of impediments to bringing a case like this, dealing with technical requirements to get into court in the first place. And there's also a time, right? I mean, where the end of the fiscal year is coming. And so we're going to see how this plays out, but this is one of many constitutional crises that we're seeing right now. Yeah, tell me about it, right? It just, yeah. Yeah, I kind of feel like after that, we just need a little pause. We need maybe a coffee break or something stiffer. I'm not really sure, but that's a lot. Okay, any other questions before we move on? Yeah.
You said twice in this last bit that Congress and also the judicial branch was institutionally not sound or not fit to do anything about this, but then you also said that they do have the power to enact an extension, and then one other thing. But can you talk about how are they institutionally not fit to handle this, or are they just not exercising the power?
Fabulous question, really insightful question. I would say a little bit of both, just as a direct answer. So the question is, are the coordinate branches, Congress and the courts, are they institutionally not well suited to push back against an outsized presidency, or are they simply choosing not to? It's a little of both. Let me describe. So institutionally speaking, and here we get to think about institutional design, which is super exciting to me, but may put you to sleep. So I will. I'm not gonna mark you down if you fall asleep right now. Just go ahead. So institutionally, the framers tell us we designed the presidency to have kind of speed and act quickly, and that's why we have one president, not three. And we've designed this office so that it can act quickly and with dispatch and with determinism to do things like protect the nation, for example, if there's an imminent attack, right, among other things, but that's an obvious example. And so the design of the office is a single head of the federal branch. It's the only branch that has a single head of the federal branch. The design of the office is to act very quickly and decisively, right? Whereas the specific design of the coordinate branches, the courts and Congress, is to act slowly. That's the whole point. It takes years to get cases to the Supreme Court and for the court to decide on them. It can take years for Congress to act on a measure. Congress can act quickly and with dispatch when it wants to, but often it doesn't, right? And it's not well suited to do that. Again, you've got two chambers that have different lines of democratic accountability, which complicates things, and you've got bicameralism, the bicameralism requirement in the Constitution. The framers didn't make this easy for Congress to act quick. And so institutionally speaking, right, the president has the advantage when we're talking about quick and decisive action. Politically, in Congress right now, both houses are controlled by Republicans who are behaving as if they're supporting the party, not their institution. And what I mean by that is they're behaving in a way that supports the president of their same party and not protecting their institutional prerogatives. They're letting things like impoundment go without any oversight, right? For example, among many other examples, that's one, just because we talked about it. And so politically, you've got a branch that's not operating the way the framers envisioned, because it's operating according to its politics, not its institutional interest. Some would say the same is true at the Supreme Court. On the court right now, you have 6 appointees by Republican presidents, 3 by Democrats. And look, this is my day job, right? I get paid to do this. I watch what the Supreme Court does. It's really, really hard for me to conclude that the Supreme Court is just not simply acting as an arm of the Republican Party today. And I don't say that lightly. It's really hard to conclude that that's not the case. I can go into detail why, if you want to sleep even more, but that, as a longtime observer of what's going on at the court, it's hard for me to conclude otherwise. And so I actually agree with the folks that say that the court has kind of put institution secondary to politics as well. There was another question, yeah. I'm sorry?
Could you elaborate?
On the court?
Yes.
Yeah, so especially on the shadow docket. I mean, look, these are savvy politicians on the court too, right? They read the Washington Post, and they know what's going on in Washington. They understand the ramifications of their decision. And yet, in over 20 shadow docket decisions where they know full well what's going on, they have cut in favor of Trump's efforts, remarkably, and allowed him to destroy institutions that Congress has created, validly using Congress's authority. Congress is vested with authority and funded. These are congressionally created agencies that have disintegrated under the watch of the Supreme Court. What's that about? Now, there are other areas of the law, too, where the court seems to be skewing toward, again, I hate to talk about politics, but I don't know how else to conclude, skewing toward Republicans. When you hold up Supreme Court decisions under the Biden era and under the Trump era, and the way that they have dealt with more or less equivalent things coming out of the White House, they have consistently cut against Biden and in favor of Trump on very similar issues in magnitude and scope and effect politically and economically. And I can go into yet more detail, but maybe we could talk after if that would work for you. Yeah.
So you talked about funds expiring at the end of the fiscal year they are disbursed for, and my question is, when these funds expire before they are used, what happens to them, and to what body of government do they return?
Yeah, good. Okay, so when the funds expire at the end of the fiscal year, they just go back into the Treasury. They don't roll over from year to year, and they're not available for appropriation at that point. So Congress has appropriated the funds. They kind of go back into the, I guess, what must be the giant bank account in the sky, and are ineffectual and inoperable unless and until Congress reappropriates funding. There's a debate right now that I'm sure you've been reading about whether the Congress will pass a continuing resolution, right? Continuing resolution means that they're passing a short-term funding measure, not an appropriations year-long funding measure, a short-year funding measure, because they can only get the votes together to pass that short-year funding measure. They can't pass a longer ordinary appropriations act. And we've seen continuing resolutions, like that's been a regular feature of our politics in recent years and decades, just because Congress has a hard time passing funding bills. Because remember, when Congress passes funding bills, that telegraphs Congress's priorities, right? It tells the president what we think is important, what Congress thinks is important, and what's not. Yes?
Presentation, you had mentioned that the Supreme Court is gaining in their power and the lesser courts are seeing their powers diminished. Is that in some administrative way, or is this only the material consequences of them acting or not acting?
Ooh, another really, really good question. Let me do a quick time check and make sure we're doing okay. We can do this, yeah? Okay. Some of you might have heard about the birthright citizenship debates. Okay, do we have time? Can I kind of go off script and talk about that? This, I think, is an illustration of what's going on in the court system today. It's not the only illustration, but I think it may be the clearest and most vivid illustration. we've taken for granted the idea of birthright citizenship for so long that to even discuss it as an issue may seem foreign to you. So let me frame it out. The 14th Amendment, enacted in the wake of the Civil War in order to overturn the Dred Scott decision that said freed black people were not even citizens, the 14th Amendment did a couple of things. It said, we're going to provide equal protection, we're going to provide due process, we're going to provide what we call privileges or immunities, basically a fancy way of saying fundamental rights, and we're going to provide birthright citizenship for anybody born in the United States. Anybody born in the United States, thus overturning the Dred Scott decision and providing citizenship for any former slaves born in the United States. Now, there's an important caveat to the clause. If you're born in the United States and subject to the jurisdiction thereof, you're a citizen of the United States. For a long time, our country said that means if you're born here, you're subject to the jurisdiction here, you're a citizen, right? The Supreme Court held that in 1898 in a case called Wong Kim Ark. Congress, in a couple of pieces of legislation, reaffirmed that language. The Supreme Court reaffirmed it in cases throughout the 20th century. And then comes Project 2025 and the Trump administration and a new theory about birthright citizenship. What this new theory says is, we're going to focus not on the birthright part of the clause, but rather on the subject to the jurisdiction thereof part of the clause. And we're going to reread that a little bit. What we're going to say is, subject to the jurisdiction of the United States doesn't mean what we previously thought it meant. What it means is your parents have to owe allegiance to the United States. Your parents have to be citizens of the United States to have birthright citizenship, right? Now, just to give some context to that, subject to the jurisdiction thereof had always been understood to mean that we're not going to recognize birthright citizenship for people like visiting dignitaries, right? Or invading armies, that kind of thing. But for everybody else, birthright citizenship. And so they adopt this new take on the idea of what subject to the jurisdiction thereof is, and say, for individuals whose parents don't owe allegiance to the United States, that meaning they're not citizens of the United States, they don't owe allegiance, therefore they're not subject to the jurisdiction, therefore they're not birthright citizens. And the Trump administration said very early in the administration, we're going to go ahead and enforce this, and we're going to remove or deport individuals that we think are not citizens under our reading of the clause. Well, lawsuits ensued, as you might imagine, to hold this up, and the lower courts unanimously held it up. One lower court, I didn't use this word exactly, but it basically was like, this is bananas. We've never heard anything as cockamamie as this in our constitutional system. And so what they did was they issued what we call universal or nationwide injunctions. And here I'm coming around to the question, if you're wondering where I'm going with all this, I'm sorry. So they issue what are called universal injunctions or nationwide injunctions, halting the administration from enforcing its view of birthright citizenship, not just here in Chicago or not just in LA or New York, but nationwide, right? Which kind of makes sense. After all, we are a nation. We'd like to have a common definition of citizenship, and the courts basically said that makes sense, and so we're going to issue you a nationwide injunction. Well, here's where things get interesting. It comes back to an earlier question as well. So these nationwide injunctions have long been controversial, and by long, I guess I mean the last 10, 20 years, but they've been controversial because what plaintiffs have been doing is they've sort of been cherry-picking judges around the country to bring a case against a president that they disfavor. Maybe it's Obama, maybe it's Trump, maybe it's Biden, maybe it's Trump too, right? Cherry-picking a judge that they think is going to rule in their favor politically and get a nationwide injunction against an administrative action that they dislike and sort of game the system in that way, right? And so these ideas of nationwide injunction, they've been controversial. Do lower courts have the authority to do this? The Biden administration, in answer to the earlier question, in partial answer, the Biden administration asked the Supreme Court to overturn this idea of nationwide injunctions. They asked the Supreme Court to rule nationwide injunctions illegal by the lower courts. The lower courts don't have authority to do this. The Supreme Court declined the Biden administration effort to do that, right? Nationwide injunctions are fine to restrain the Biden administration, but when the Trump administration comes up in the context of birthright citizenship of all things and says nationwide injunctions exceed the boundaries of authority of the lower courts, you know what the Supreme Court says? Yeah, you're right. Really? And so immediately that authorized the Trump administration to go ahead nationwide, except for the plaintiffs in the case, and enforce its view of nationwide citizenship. Now, we're working that out in the lower courts. The lower courts have renewed nationwide injunctions under different authority. Things are kind of proceeding now the way that they should have in the first place. But my point is, the Supreme Court has said lower courts don't have this power to issue nationwide injunctions, even in a case as clear and obvious in our constitutional system as birthright citizenship, right? And in that way, among others, in that way, the Supreme Court is kind of seizing this power. Now, there is another way that we're seeing, that is on the shadow docket. When the Supreme Court's ruling on the shadow docket, it doesn't explain its decisions, or mostly doesn't. And yet it expects the lower courts to adhere to them. And so we've seen several times now where Supreme Court justices have publicly slapped down lower court judges because lower court judges don't know how to apply a decision that has no reasoning behind it, right? I mean, that seems like kind of an unreasonable thing to ask a lower court judge to do, and yet that's what the Supreme Court is doing. So the Supreme Court seems to be seizing a lot of power, taking away power of the lower federal courts, and that I think is an important part of this picture. That was a really good question. I spent way too long on that. I'm really sorry. Anything? Yes, ma'am, please.
This the passiveness or issue of party over institution, how can it be prevented now in the future, and can it be?
Ooh, that's the big question, right? Wow, do I wish I had an answer. My instinct is, so I'm going to tell you a law professor trick, okay? Maybe you know this, maybe you don't. Maybe your professors here at COD use it as well. But when you ask a question that we don't know, which I'm going to reveal something, happens all the time. When you ask a question that we don't know, our answer is, what do you think? And so I say to you, what do you think? In seriousness, I mean, that's the problem of the day. How do we work that out, right? And it's not a problem just with Republicans. Democrats do the same thing. We saw that in the Obama administration and the Biden administration. I don't know how to work that out. That's above my pay grade. But I think we as a people do. And we can work that out. So I hope, that you all engage in the civic education and civic involvement efforts here at COD, because they really are fantastic and will help us collectively solve problems like that. Yeah, that's a non-answer, and I'm sorry, but yes.
Do you see lifetime appointments ever ending? I mean, to me, that's the main part of the problem.
Right. No, because it's hardwired into the Constitution, at least by our understanding of it. And the Constitution is just so hard to amend. Jill Lepore has a great new book out. It just hit the shelves yesterday about history of our Constitution and the amendment process and how difficult the document is to amend, which is weird. In contemporary democracies, they can amend their constitutions way easier than we can. Ours is a real outlier in that regard. So there are creative solutions around it, though. We could rotate Supreme Court justices off the Supreme Court, lower court judges on. We could have Supreme Court justices hear cases in 3-judge panels like the lower federal appeals courts do, instead of as a 9-court bench. There are some other kind of creative solutions around that. I just don't see any of it happening. You might remember in the Biden administration, he commissioned a study of different ways to adjust the Supreme Court, let's say. And it's a great read. It's a really interesting read. for a con law nerd like me, but is it going to go anywhere politically? I don't think so.
Given all the creative ways of exercising power in the office, do you still have confidence that democracy can withstand all of this? Like it's durable enough to be able to do this? Or are there things we should be looking for to address it more actively?
What do you think? Look, I was saying to the organizers before today, I'm worried enough about the state of our democracy that I'm teaching as an overload a seminar every spring on democratic backsliding and moves toward authoritarianism. There's a lot of really good work out on this because we're seeing it globally. This is not an issue in the United States, it's a global issue. And there's a playbook for democratic backsliding, right? There are a list of a dozen or 24 things that authoritarians do when they're elected to office. We've seen it in Brazil, we've seen it in Hungary, we've seen it to some degree in Turkey, in Poland, in India, a number of other countries, and it's the same playbook. There's nothing new here. And what we're seeing in the United States is kind of check every box, one after another. It really is quite terrifying to me. Now, you may feel differently about that, and if you have more hope, that's great. I applaud that.
Does it give you confidence? Is there anything that you see as like pushback?
Yeah, I'm going to tell you what gives me confidence. This is going to sound really sappy, and so I'll apologize in advance, but conversations like this, I truly believe in my heart that having conversations like this and civics education and civic engagement, in my heart, I truly believe that's what we need to do to solve this problem. And so that's conversations like this. This may not feel like democratic action to you. It doesn't feel like going to the voting booth, but it is. And by asking questions and engaging, you are engaging in democratic action. What I would say is, go back to your communities, go back to your family, go back to your friends, and have these conversations with them and learn together and ask the question, what do we do in this moment? If anything, maybe we like this moment. Maybe we want more of it. If we don't, what do we do to get away from it, right? Have those discussions because that's where democracy happens. We think of it as a voting thing. Yeah, that's part of it, but it's really the conversations we have. Yeah.
We have a question that was sent in.
Please.
All right, are you ready for this question?
I'm ready, bring it.
All right. Is the house on fire?
So variation of the question, are we in a constitutional crisis, right? I'm going to say right out of the gate, and this sounds really weak, and I apologize for that, but there's not a universally understood, agreed upon definition of house on fire or democratic crisis, constitutional crisis. We just, a lot of people disagree on that. And a lot of people say, yeah, we're in a constitutional crisis now. In fact, a lot of people said we were in a constitutional crisis the first time in this administration that the president looked like they were going to not comply with court rulings. Now, that's almost normalized in our politics somehow. And so is the house on fire? Are we in a constitutional crisis? I'm going to decline to answer the question, but I will say that I think we are in a dire situation. Can we do anything about it? I'm going to leave you with this, if I could, okay? The trend line that we had on the board a second ago, we didn't get to a lot of stuff. I'd be happy to talk to you individually about it. But the trend line that we had on the board a second ago started with the Supreme Court. You might remember the Supreme Court started this trend line of power toward the presidency. It was a jurisprudential move of the Supreme Court. And what I mean by that is court rulings had started to lean in favor of an outsized power to the presidency and reducing the power of Congress and administrative agencies. It was doing that in a lot of different ways. Some of it was how the president, or if the president, had authority to hire and fire independent members of the executive branch, like, for example, Lisa Cook at the Federal Reserve, which is, in the headlines today. Does the president have authority to do that? What we've seen is the Supreme Court moving in the direction of, yes, the president has the authority to do that, even though it was as recent as 1988 that only one member of the Supreme Court signed on to what I earlier referred to as a unitary executive theory that would authorize the president to do that. That's how much our judicial politics have changed just in the last few decades. It's head spinning, it's whiplash. So the unitary executive theory is the idea, it comes in different variations, but the idea that the president has control over the officers. First, think about it as concentric circles. First, the officers within the executive branch, right? That's the most narrow version of it. Then the employees within the executive branch, that goes out a little bit farther. Then the agencies themselves in the executive branch. And then the funding and the law itself as it applies to the executive branch, that the president has plenary unilateral control over those things. And depending on your version of the unitary executive theory, it might be more narrow or more broad. My point is, the unitary executive theory had the vote of a single justice in 1988. Today almost surely has a solid vote of 6 on the Supreme Court. And the Supreme Court has been moving inexorably in that direction, empowering the president at the expense of administrative agencies and Congress. That's been a jurisprudential trend that is independent of what's going on in today's politics. That set the stage for what's going on in today's politics. And as I had suggested a second ago, that trend met Project 2025 and the Trump presidency with a president and a movement that was willing to take that jurisprudential trend and run with it, right? And then that running with it met with a Supreme Court that was willing to use its shadow docket to even accelerate that trend toward a more empowered presidency, again, at the expense of administrative agencies, at the expense of Congress. So here's the thing, and this is what I'll leave you with in response to some of these wonderful questions toward the end. What do we do? This is a decades-long trend, and it didn't just happen, right? These things didn't just fall out of the sky. The Supreme Court might have ruled in a way in 1988 and moved away from that in the early 2000s in the last couple of decades, but that wasn't an accident, right? That was the result of a careful, deliberate, decades-long political, jurisprudential effort by people just like you in this room. People who are smart, who are dedicated, who are passionate about their version of separation of powers and what government should be all about. And they went out and did the work to make it happen. They did the work through ordinary democratic channels. They did it. And in the matter of a couple of decades, they fundamentally changed our separation of powers to create the conditions today that we have an outsized presidency, and where I, as a longtime observer of constitutional issues, am deeply concerned about democratic backsliding and authoritarianism. That's remarkable. That's a remarkable effort that those committed, passionate, small d Democrats made in our system. Well, this is what I tell my students. That was a long effort by these Democrats to make the changes that they wanted to see. If they can do it, we can too, right? Maybe you like those things, maybe you don't. If you like them, go. You got a movement, right? Like the politics are with you right now. More power to you. You've got your wind at your back. But if you don't like it, you've got a model for changing this. There's democratic action that we can take in the courts, at the voting booth, in conversations like this, in other ways where we can make that change too. And it starts here, just with conversations exactly like this. So I think with that, I'm going to stop listening to myself talk. Again, happy Constitution Day, everybody. Thank you.